Okay. Like I said, we are delighted. We are very glad to have you with us because this is our first webinar, the one we are holding today with Mr. Artur Cichocki of Poland as our speaker. So for the past year, we have developed both the infrastructure of the WOLEP network, but also the community of lawyers within WOLEP. As you may have noticed from our newsletters, and we are very glad to say that for the past year, WOLEP has become a respected hub, both for networking between lawyers, but also for doing business together, which is one of the aims of the project. I'm joined here by Mr. Romeo Cosma. He's the man behind the WOLEP network, the idea of having a professional network of lawyers, and also by another colleague of ours, Mrs. Adelina Zapis, who, like I said, is the Director of Development for the WOLEP network.
Hello, everyone.
The speaker who was very kind to respond to our invitation and to hold this webinar is Mr. Artur Cichocki. A few things that I'm very pleased to tell you about him is that he's a Polish lawyer. He's an expert in immigration law and also in new technology law. And today, Mr. Cichocki will be presenting a very hot topic at the moment, which is smart contracts.
Yeah.
I know that many people around the world, around the globe, are very interested in this subject, and all the more the lawyers, because going forward we will be hearing very much about this subject. And like Mrs. Pasquali from Italy, also joining us today, said earlier, it is very important as a lawyer to improve professionally and to continually gain new insights and new information regarding the topics that are changing the legal profession and the legal environment. So without further ado, I now give the floor to Mr. Artur Cichocki, but not before telling you that, kindly inviting you that after this presentation of Mr. Cichocki, we also have a Q&A session of maybe about 10 or 15, 20 minutes. So we invite you to ask the speaker your questions and maybe your thoughts on the subject to present them after the webinar. Okay, so Mr. Cichocki, we are all ears.
Okay, I have one question. How I can put my presentation?
We can also share it for you if it's okay, and
Yes.
you can tell us whenever you want to change the slide. Is it okay?
Okay. Okay, we start. First of all, thank you for giving me this opportunity that I can present my work and what we do in my law firm. I am a member of the Warsaw Bar Association. I conduct my law firm in Warsaw, but we offer legal services in all the Poland. With my coworkers, we have 10 years of experience in law. In general, we offer services in civil and criminal procedure law, economic law, and technology law. We can change slide?
Yeah, sure. So the next one, introduction.
Yes, please.
Okay.
Yes, it's okay. Blockchain, it's how we know it's new technology, and Some people have a lot of problems with understand how function, but a lot of times we can hear about bitcoins, about cryptocurrencies, and other cryptocurrencies, and these prices about these cryptocurrencies are very high now, and people thinking about invest in these cryptocurrencies. But it is important from my point of view, smart contracts too, because it's type of blockchain. And if we start, it is often found that the law does not keep up with the practice of everyday life. For example, when the internet was becoming more and more popular, people started concluding contracts through it, e.g., a sales contract, a rental contract, etc. As a result, there were problems with the interpretation of whether the contracts concluded in this way are at all valid. The courts often had to deal with this. Over time, this has led to a situation where the law regulating, for example, the issue of concluding contracts was changed. For example, the possibility of making declaration of will by means of remote communications means, e.g. the internet, telephone, was introduced. This change had far-reaching consequences. If a contract, e.g. over the internet, is concluded between the trader and the consumer is often the weaker party of the contract. A trader striving to maximize profit often presents his commodity as having only advantages without disadvantages. The consumer cannot physically touch the purchased product, which in the photo may differ from its real appearance. Therefore, at the level of European Union legislation, it was thought that when making such purchases, the consumer would have the right to change his decision and withdraw from the contract. Today, various types of platforms through which we make purchases do not surprise anyone. The need to use them in the era of coronavirus was even more emphasized because it limited the interpersonal relationship. Such platforms are e.g. eBay, AliExpress, etc. In every European country, there are certainly platforms that work locally. All of this is just a brief outline of how new technologies slowly change our lives. They become a part of it, slowly getting us used to new forms of shopping, concluding contracts, etc. And in this way, from my point of view, smart contracts can change our life too, because today we don't speak or speak a little bit only about smart contracts, but how I can mention, from my point of view, smart contracts are the future. All this is also a sign that new technologies are entering our everyday life more and more. E.g. the Internet of Things, cryptocurrencies, like I mentioned, smart contracts, and others. Today, without new technologies, life would be more difficult. Therefore, today, I will introduce you to a small section of the law of technologies, new technologies, which is the subject of smart contracts. To start talking about smart contracts, I think we need to start with the blockchain and smart contracts and definition about this subject. There is no single definition in the science of law My proposal is that it is the best adopt a definition that describes a given thing as accurately as possible and as understandable as possible. It seems to me that the most important thing is simplicity in order to create definition in a simple way. Therefore, blockchain is a growing list of records called blocks that are linked together using cryptography. Each block contains a cryptographic hash of the previous block, a timestamp, and transaction data. The timestamp proves that the transactions data existed when the blocks was published to get into its hash. As blocks each contain information about the block previous to it, they form a chain, with each additional block reinforcing the ones before it. Therefore, blockchains are resistant to modification of their data, because once recorded, the data in any given block cannot be altered retroactively without altering all subsequent blocks. And this was definition of smart contract, and this was definition of blockchain. And definition of smart contract is a computer program or a transaction protocol which is intended to automatically execute, control, or document legally relevant events and actions according to the terms of a contract. The objectives of smart contracts are the reduction of need in trusted intermediaries, arbitrations, and enforcement costs, fraud losses, as well as the reduction of malicious and accident exceptions. Smart contracts were first proposed in the early 1990s by Nick Szabo, who coined the term, using it to refer to a set of promises specified in digital form, including protocols with which the parties perform on these promises. Now I will be speaking about operation and systematic of smart contract. Smart contracts are simple programs stored on a blockchain that run when predetermined conditions are met. They typically are used to automate the execution of an agreement so that all participants can be immediately certain of the outcome without any intermediaries' involvement or time loss. The most important thing is that they are computer programs, they are executed on a blockchain, their execution is autonomous. How smart contracts execute? The concept of smart contracts was proposed, how I mentioned, by Nick Szabo, an American computer scientist and researcher of digital currencies, in 1994. The smart contract is executed through a blockchain network, and the code of the contract is replicated on many computers that comprise the network. If we are talking about the division of smart contract, we can find various divisions of smart contracts, especially in scientific doctrinal considerations. E.g., complete smart contracts, clean smart contracts, hybrid smart contracts. Today, the use of such a division has only a scientific dimension from my point of view. because it doesn't not matter much in the practical use or application of the law. Application, like any new technology and the use of smart contracts, at the beginning, it raises many concerns and hopes. The use of smart contracts will undoubtedly be important for the legal and economic sciences. The importance of smart contracts for the legal sciences can be considered from a dogmatic and theoretical point of view. A dogmatic view of smart contracts may call into question the functioning of existing concepts and institutions. Automatic assets value regulations raise questions as to whether such solutions are actually fully legal. At this point, reflection on legislative activities would be required, as too restrictive legislative activities could result in the migration of entrepreneurs from such rule of law. Keep in mind that smart contracts are generally computer programs, so transferring them to other, more favorable jurisdictions is not a problem, such a multa. On the other hand, under stymieing the threat posed by the use of a wide range of smart contracts without any jurisdictional controls seems dangerous. If any damage is done, then the aggrieved person will usually want to go to the police and seek help in claiming their rights from the country in which the damage was caused. Smart contracts are criticized because of their formalism. The content of the contract has been written in the code, and there is not possibility of its interpretation. Classical contract, we can. Do you hear me?
Yes, we hear you, Mr. Cichocki.
Okay, because I thought I had problem with internet. Okay.
I hope the other attendants are also hearing you. If someone can confirm, please.
Yes, I hear you.
Yes, we can hear you.
Yes.
Okay, thank you. We continue. The content of the smart contract has been written in the code, and there is no possibility of its interpretation. Traditional contracts, if we write on paper, always we can interpret, and we can go to court if we don't understand this contract, or in other cases. In the case of blockchain, of smart contracts, it is impossible because somebody tell that code is law. We can interpret this code in other way, like it's wrote. As has long been known, the law should not be too formalistic, but should consider, for example, the social context. In the case of traditional civil law, in the event of disagreements between the parties to the contract, the judge has the opportunity to analyze the circumstances on which the contract was concluded. The language used by the parties and their level of knowledge of law, it is important too. On the other hand, it is argued that the natural language we use is imprecise, ambiguous, and therefore creates misunderstandings and disputes. Somebody tell that code is better. Law, if we write contracts in code, is better because we don't have misunderstandings. In the case of smart contracts, There will be no such problems, how I mentioned, but the parties to the contract will not be able to refer to the context of its conclusion. The question arises, are smart contracts to function alongside or be part of the law system? Can law not be interested in those in transactions that are concluded on the blockchain? In this point, I refer if smart contracts are part of legal system or not, because how I mentioned too, some bodies think that code is law. Law is in code, and if we have smart contract exists only in itself. Smart contract don't need legal system. I explained this point of view today in my presentation. From an economic point of view, the importance of smart contracts for global economy is bound to the change. Some economists believe that by 2027, instruments using blockchain technology will account for 10% of the world's gross product. Among the opponents of smart contracts, it can be found that the blockchain is pure speculation and that it will collapse sooner or later. Such claims seem unfounded as smart contracts are gaining more and more recognition. They are trusted more and more, and as you know that is new, you must earn a positive opinion. Therefore, it seems to be a matter of time when the use of smart contracts will become more and more popular. Financial institutions are particularly interested in smart contracts. This is due to the fact that they are interested in their automation and thus lowering costs in the case of contracts concluded on the basis of strictly formalized and reputable conditions. Now we speak about legal regulation regarding smart contracts. In most countries, the legal issues related to smart contracts are not yet regulated. How I mentioned, some bodies think that code is law, but it should be asked whether this issue should be regulated at all, or maybe the legal regulations in force in given countries already allow to us of smart contracts. After all, they are contracts, and in most legal systems, the will of the parties to the contract may be expressed in any way, unless a specific provision provides otherwise. Of course, there are already countries where there are special legislation on smart contracts of their legal definitions. E.g., Malta, the state of Arizona in the USA, for instance. Could you change slide to next? Oh, thank you. Yes?
You are welcome.
Oh, okay. Now we speak a little bit about smart contract as a declaration of will. Somebody speak declaration of intent. I used two forms. Declaration of will and its form. The key issue is whether a declaration of will can be made via blockchain technology. As previously mentioned, the legislation of each country provides the form in which a declaration of will to conclude a contract may be made. It is generally accepted in the continental legal systems that any behavior externalize the will of the parties to enter into a contract is acceptable, unless specific provisions regulate this issue differently. E.g., in the case of the sale of real estate, the form of notarial deeds is required. It is important to pay attention to the fact whether if the subject of a smart contract is to perform a legal action illegal. It can be argued that such a contract will be valid, e.g. selling drugs, selling a stolen car, etc. It seems that such a contract, although concluded by parties of a smart contract, will be invalid by law. Do we need a new legal form, e.g. a blockchain form? As of today, making a declaration of will by means of a blockchain cannot be considered as making a declaration of will in a special form, because the law does not provide for such a possibility. For this, it would be necessary to change the law and introduce a new form of declaration of will, i.e., a form of making a declaration of will by means of a blockchain. In this case, statements could be made via blockchain, e.g. regarding the sale of real estate. And if we speak about moment of submitting the declaration of will, we must understand that in the case of declaration concerning the conclusion of performance of a smart contract, the reason for the failure could lie in a lack of funds or a defective signature, but also in the incorrect use of the smart contract function or errors in the declaration itself. A statement expressed in a programming language or in the execution of a function programmed in a programming language is machine interpreted. Therefore, when an error occurs, the intent blockchain operation will not be performed. Depending on the software, a failed transaction may be saved as a failed transaction, or it may be unsaved. A transaction with an annotation about its failure should not be treated as a declaration of will submitted in the form of a blockchain due to its defectiveness in relation to the technical requirements. And if the intention of the person submitting the declaration of will was to submit it in the form of a record on the blockchain, but in the end it was not included in any of the blocks, then it cannot be considered that the declaration was made to another person because he could not read it. When discussing the moment of submitting a declaration of will in the form of an entry on a blockchain, one can see some similarities to declaration made using other technical means, e.g. a declaration of will submitted via email may be destroyed if, for example, the recipient uses a device that does not correctly display the characters used when placing statements. Appeal and invasion of the declaration of will. The difficult issue is to revoke a declaration of intent made using the blockchain. The difficulty arises from the nature of such a statement. There is also a problem with the blockchain approving such revocation of declaration of will. It is difficult to admit that such an activity would look like. If the declaration of will has been made in the form of a blockchain, its execution automatically begins. In this respect, the intervention of the legislator would be necessary to determine whether and how such revocation of the declaration of will would be possible. because now, today, in general, is in civil law, we can appeal and invasion of the declaration on will. But from my point of view, and according to my opinion, in case of blockchain smart contracts, today it is impossible. We need intervention of legislator. For instance, in Poland, blockchain is not regulated. Smart contracts are not regulated, and people can use. We can buy bitcoins, Ethereum, and other cryptocurrencies. Evasion. Now we speak. Okay, annulment of the declaration of will. Sorry. Now I will speak about evasion of the declaration of will. 5 phrases. In the declaration of will has been made, but it is defective. Under classical civil law, it is entitled to avoid the legal consequences of such a declaration. A defective statement may be made, for example, a mistakes or threat. The question is how, in the case of smart contracts, it is possible to submit a declaration of avoidance of the legal consequences of the declaration of will. Should the same contract code provide for such a possibility? That if such a possibility exists but will be abused. It seems that the legislator's intervention would be needed to solve these problems with the use of smart contracts. Annulment of the declaration of will. Is it possible at all without the intervention of the legislator, who will allow the possibility of invalidating the declaration of will submitted by means of blockchain? Could you put next slide? Smart contracts as a contractual relationship. When we start our presentation, I told to you that some are people who think that code is law, and in major of legal systems we have freedom of contract, and code is law. Adherents believe that smart contracts are a closed system and do not need traditional law to be effective. This is, of course, from my point of view, misunderstanding, because all those smart contracts are computer programs. Declarations of will made with them have legal effects in the sphere of applicable legal norms. We can create alternative legal system, because if we speak about smart contracts, and if we approve that smart code is law, from my point of view, we step by step create alternative legal system, and I'm convinced that will be better if smart contracts, if we use in external sphere, will be part of a traditional legal system in every country. The possibility of making a declaration of will by means of a smart contract results from the freedom of contract and human autonomy. The principle of freedom of contract is one of the pillars without which it is difficult to talk about the admissibility of using smart contracts in trade. It is this principle that allows to parties to arrange the legal relationship and their own discretion as long as it lawful. It is a pillar that allows smart contract to be treated. The receipt plays an important role as it proves that the debtor has fulfilled the indicated obligation and thus protects the debtor's interest. In the case of contractual relationships based on a smart contract, there is no doubt that the performing debtor is entitled to a receipt. It seems reasonable to allow such a receipt in the form of an entry on the blockchain, but the parties to the contract must provide for this possibility in the smart contract itself. The content of the smart contract: the parties may conclude a contract in the form of a smart contract of any content, as long as it does not violate the provisions of generally applicable law. In the case of smart contracts, it is not necessary to enforce them if one of the parties does not want to fulfill its service. This is because smart contracts are self-executing. Interpretation of contracts based on blockchain technology. In this case, there is no need to interpret a smart contract because when creating the code, the parties enter the provisions of the contract in it. Doubts of interpretation should emerge at the time of creating the code, no later. Could you change slide, please? Now I will speak a little bit about security of legal transactions. First of all, we must remember about the DAO hack, if I would like correctly. DAO hack was the hack into the DAO. DAO was a smart contract based on the Ethereum blockchain. The DAO have object to raise funds, collect money in the other cryptocurrency and invest this money. Of course, there were no intermediaries in this project. There were no managers other than the investors themselves and the code of smart contracts. The DAO started the fundraiser on April 30, 2016, and it listed 28 days. Around 11,000 people took part in the fundraiser, and cryptocurrency was raised worth around $150 million. Soon after the fundraiser ended, it turned out that there was a bug in the code and another person created a new smart contract called the DAO child and paid out $3.6 million Ether units for it. The attacker did not manage to pay out all the funds because the community took corrective measures. If we speak about theft, it is possible because in past a lot of people thinking that nobody can theft, for instance, bitcoins. But from my practice, I can tell that what this happened in Poland because I countered this my law firm with one colleague. We conduct this case that blockchain was theft from one city to other via internet. And with falsification, I think it is impossible because how I mentioned when I start my presentation, it is code. Code is impossible falsificate. Could you change slide? Smart contract efficiency, practical significance. I think if we speak about smart contracts from practical point of view, if we use these contracts in wide range, we don't need third party. Third party, for instance, if we sell real estate, is notary, because parties, if would like conclude contract, seller and buyer must go to notary public, and with smart contract it is not important. Can we go to QA session? Any questions?
Okay, thank you. That was a great and enlightening presentation and webinar, Mr. Cichocki, on such an exciting topic. I think I am speaking for everyone attending that you have offered us a very interesting and eye-opening webinar. It really improves our understanding of smart contracts, and so applauses are in order for Mr. Cichocki. Please open your microphones for applauding his effort, the effort of our speaker. Thank you. So we are now ready to begin the quick Q&A session and take your questions. We also have some questions, but we will first let the other WOLEP members and attendees to address their questions to our speaker. So feel free to.
I would have a question. Is it okay?
Yeah, sure.
Well, I thank you very much, Artur, for your presentation. I must confess I was very excited about your topic because, you know, we have smartphones, smart houses. So what are smart contracts? In this context, I would like to ask you, how do you see our profession in this context? Because basically, if I understood correctly, smart contracts replace the lawyers. So what is our role there, and who drafts these smart contracts? Because I understand that the parties enter the code, and if the conditions are met, then the contract it executed itself. But who writes the contract?
Yes, thank you for these questions. I hear the same words what you mentioned, that if smart contracts develop, lawyers, people don't need lawyers. Our profession is not important. I have opportunity to speak with one professor of law, technology law from Poland, and he told me that law must change, law must develop, and not only law, but mentality of lawyers. In 21st century, we can work only themselves, but we must cooperate, from my point of view, with programmers, with other people who write these contracts. We must unite. We must go together with ERA IT, I think, and I suppose that lawyers can't write these smart contracts. It is impossible, I think, but perhaps in future can exist this type of person. But I think we must collaborate with other professions. For instance, if we have cases in our law firm, we are collaborate with other lawyers, because law in Poland is very complicated, changes very fast, and it's impossible that one lawyer can know all details, jurisdiction, jurisprudence, etc. No, and I think we must move this idea that we don't work in any case only one person to smart contracts.
Okay, great. Thank you.
Thank you.
Allow me to intervene a bit. So, Mr. Cichocki, thank you for the answer for Mrs. Horoi. I think it was as enlightening as the webinar itself. And we have the next question coming from Mr. Mohamedou Aminu. He texted us on the web chat, on the chat of the presentation, and he wants to thank you for your presentation, and addressing the question is namely, does this mean that lawyers have to get new skills in coding to be able to assist their clients? Is the question of Mr. Amino for you.
Thank you, Mr. Amino. I think it's a similar question that we can hear from Ms. Horoi. Sir, I think lawyers must be able to collaborate with programmers, with people who can write this contracts and know IT era. I think. For instance, in past in Poland, we have this attitude that lawyer, attorney at law was very important person, because lawyer know bills, know how function courts. But now these rules, all people can find on internet, and I think we must change our attitude. We must be more closer to our client. We must more hearing our client and collaborate with other professions.
Yes, and if you again allow me to intervene, Mr. Cichocki, I think that what history proves is that again and again lawyers were very versatile and adaptable to all changes throughout the history and throughout society as a whole. And I'm sure that this challenge will be met by lawyers around the world. So again, thank you to Mr. Aminu from our African, let's say, contingent of members from Rwanda, namely. He's a founding partner of his firm, of his lawyer's office. So again, thank you. The next question, if anyone else wants to address it, please.
Yeah. Hello.
Hello.
Yes,
Hello?
Mr. Kuzma.
Yes, we hear you, Mr. Amino.
Yeah, Mr. Amino. So I would like to go deeper and further to according to the answer of the presentation. But so where will we situate the, how do you say, the confidentiality that lawyers have if they have to put another person like a programmer in the field? Will the programmer will be concerned with the principle of confidentiality that we have with our clients in these cases?
A great question for Mr. Cichocki. Thank you, Mr. Amino.
Yes, it's great questions. It's a great question. I must tell that I don't know now, because you are right. Our profession have confidentially clients go to our law firms, speak about secrets, about a lot of things. Perhaps in the future will be possible sign with programmers contracts about cooperation and obligate these programmers to maintain in silence all what they could obtain during our collaboration, I think. But this is a good question. I don't know. Today, I don't know. But I think life show us a solution, because in history, a lot of times life show solution, I think.
Yes, I think very thoughtful and interesting answer to your question. But thank you, Mr. Cichocki. We would like to take some 2 more questions, if possible. If anyone wants to address another question, we invite. I saw Mrs. Sonia Pasquali from Italy. I don't want to involve you if you have no question, but I saw you taking notes about the topic.
Yes, I was taking note because as I told you immediately, I don't know actually anything about this topic. So
no, you didn't know, sorry, you didn't know before the start of the webinar, but now you know plenty more. Okay, so
now I was thinking about the cooperation with some, I don't know, for example, with the programmers. We as a lawyer already cooperate with other professionals. Let's think when we have to cooperate with, I don't know, accountants or translators or doctors, if we have to ask to our clients to go for a visit for the trial. So we already cooperate with other professionals. So I don't see any matters in this. I have to analyze but I think I just have to study, because my only doubt was about the hypothetical absence of the third party. Because, for example, in Italy, we have rules about how to form the contract. So if, let's say, some contract may be, let's say, signed verbally, some other requires the written form, but some others, like real estate, requires the notary, but because they have to be published on public registrations. I don't know the English form of this. So that was my only doubt, but I don't know if it's something that I just missed about this topic, or if it's something that Mr. Cichocki can explain.
Okay, in Poland, we have the same rule, I think, because from my point of view, I collaborate with accountants, with people who are medicine, work in hospitals, but if I need any help, for instance, from accountant, I can send only this part of documents that not any secret of my discountant who will send me my client. And I have this solution that I prefer that my client go to doctor, go to accountant, and present documents, and I only send my question.
Okay, I hope Mr. Cichocki settled a bit of Mrs. Pasquali's question. It is a work in the making, that's for sure, about smart contracts, and I think the whole domain will only grow in the next decade. So for the last question, do we have another question from you? I for one didn't know that that seemed a very interesting bit, the part that one of the first proposed versions of a smart contract was in the 1990s. So it really has some depth, this topic, and it was developed for 3 decades almost. I don't know, maybe even more. Okay, so if we have no more questions, I would like to point out that Adelina, my colleague who is in charge of network development, will send all of the attendants will send the presentation of Mr. Cichocki, and we will also upload it and make it available to WOLEP members on our website, wolep.com. We would like to again thank everyone for taking the time and for participating and getting involved in this discussion. And I am sure that it will only grow from here on. And we would also like to invite all of our members to propose topics for the next webinar, which we hope to host in the coming months. So again, thank you. And I would like to offer the last words of the presentation to Mr. Cichocki, of course, because he's our host.
Thank you very much for this opportunity that I can present my point of view to smart contract. Thank you for participants, and I think we can collaborate, and I think we have opportunity to exchange our experience and perhaps collaborate in real life. Thank you very much.
So again, thank you for attending our webinar. Sorry, there was a technical glitch. I think it was a memorable occasion for all of us, and we'd like to point out if and when someone who attended the webinar has another idea for an interesting topic and for an interesting webinar, if someone maybe volunteers to host the next webinar, he's welcome to propose and to come forward with his suggestion and or her suggestion. So again, a great evening to you all, and we'll keep in touch through our platform and through Adelina. A great evening. Bye-bye.
Great evening. Bye-bye.
Great evening. Bye-bye.
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 Ciao, ciao, ciao.
Chao.
Entregar con ocasión a la promesa de contrato.
Bye-bye.
Ciao.